U.S. Supreme Court heard oral arguments in a case of 5 pro-life pregnancy centers that are challenging what they say was an unconstitutional investigation by New Jersey's Attorney General. The case is First Choice Women's Resource Center versus Platkin. And arguing on behalf of those pro-life pregnancy centers was Alliance Defending Freedom. So how did it go? Well, joining me now to offer his analysis of the hearing and the case is ADF Senior Counsel Caleb Dalton, who was in the courtroom today. Caleb, welcome to Washington Watch. Thanks for joining us.
Tony, thanks so much for having me.
Now, I was talking about earlier how there's nothing new under the sun. This sounds very similar to what happened coming out of California a few years ago, that ADF handled that case as well, where Kamala Harris was then the Attorney General and was going after the First Amendment freedoms of care pregnancy centers out there. It looks like the left will not stop trying to shut down these care pregnancy centers.
No, First Choice, our client that we were honored to represent at the United States Supreme Court today, they provide free compassionate care to women in need. These are women who are going through situations they never imagined they would be in, and First Choice provides the resources they need to make the right choice to protect their babies' lives. And as you know, Tony, I mean, the studies show that when those resources are available to women, they're more likely to choose life, and that's what First Choice does here. And because the Attorney General doesn't like that choice, that's why he's targeting these pregnancy centers for harassment and intimidation, and the First Amendment doesn't allow that.
What's the justification for going after their donors? That's what he's subpoenaed. He's requested, he's demanded, I should say, their donor information. Based on what?
He's asking not only just for the identities of their donors, he wants their addresses and their phone numbers. And the allegation is maybe the donors didn't know that First Choice pregnancy resource centers were pro-life. And that's absurd, frankly. Not only are they absolutely clear about who they are and what they do on their websites, the Attorney General doesn't need that information. If the law was violated, he could enforce the law without that donor.
What possible violation could there be?
There's not, and if there was, he would have already filed a lawsuit. That's why he's using the subpoena power to harass them and try to chill their speech and try to chill their donors from donating to them.
That's exactly what this is about. We've seen the same thing in other cases where state officials, almost always in blue states, trying to intimidate these conservative Christian organizations by having this chilling effect, because the donors don't necessarily want to be harassed. I remember back during the marriage debates where people would show up at the homes of donors to harass them. I don't want to run out of time here, Dalton. What was your sense from the questions asked by the court? Did they see through what the Attorney General in New Jersey was trying to do?
I think the court did. As the adage goes, I think at the end of the day, you ask, would you rather be us or the state of New Jersey? And I think you'd rather be First Choice pregnancy centers at the end of the day today. The court absolutely saw through this facade. Justice Barrett asked questions about the harassment and kind of the past statements the Attorney General has made by setting up this strike force to go after pregnancy centers. And Justice Thomas asked the New Jersey Attorney General's attorney, were there ever any complaints that triggered this investigation? And the answer was no. There was nothing that justified this other than the Attorney General's ideological opposition to First Choice.
So Caleb, did anybody ask him if he had anything better to do than harass an organization that was helping out women in crisis pregnancies?
That's a great question. He should have better things to do because First Choice deserves his support, not his harassment.
So, Caleb, this case, oftentimes, I mean, it depends. Sometimes the court has a very narrow decision that just affects the particular client before the case. Could this have ramifications across the country?
I think the biggest ramification of this case is whether or not nonprofits will be able to vindicate their rights in a federal court if they face political harassment by a hostile Attorney General. And this is across the board. We're at a crossroads as a nation where the justice departments have been weaponized. We've seen that at the federal level and at the state level through different politics being played with justice. And that's not the way it should be. And the question before the court is, when an attorney general is playing politics with the justice system, can you go to federal court and preserve your First Amendment rights? And the answer should be yes.
So what New Jersey was trying to do is keep them bottled up in state court where they really had no relief.
That's right. And that's not how the First Amendment or the federal statutes that authorize you to protect your First Amendment rights, that's not how they work.
So we expect a decision on this at the end of the court's term?
By June at the latest, but it could come earlier. This isn't a decision I think that should take the court very long to write. So it's possible we see an earlier decision, but certainly by the end of June next year.
All right, Caleb. Again, we appreciate Alliance Defending Freedom and the great work that you guys do across the board defending our first freedom. Thanks for joining us.
Thanks, Tony.